me now.
I am Cornholio.
Hi, how you doing? Where you from? What do you do for a living?
All week long.
Order in the court. It's time. Got a case.
Is that lady got a neck brace on? No, never mind. It's a scarf and a chin strap. All right. I thought they morphed together. I was like, Your Honor.
Most importantly,
behind.
Judge Boyd's flowers are on point today. I actually like those.
Those are nice. Those are nice.
Always
Good
nice to
ensemble.
check it. We check it. Oh, look at this one. Nicole's got her little baby behind her running around the house.
Kids there.
That's nice.
She may feed it soon, Creed.
Oh, and she's like me with the allergies. You see that out of nowhere. It's a
She's
nice
rubbing.
day today. The daffodils are popping up everywhere, and Creed's already through the itchy eyes and the blowing of the nose.
It's going to be grass cutting time before we know it.
Yes, our hero, Mikey, who one and done, one pump chump with the YouTube now.
We got lucky on the look. This time around, I knew every single thing. I felt like I did, at least. I felt like I knew exactly what they wanted to hear. And that's when you're fighting with YouTube, that's the best thing to do is just tell them exactly what they want to hear. Nothing more, nothing less. Hit all those buzzwords.
Yeah.
You'll be all right.
So those of you who don't know what we're talking about, we got a chase channel, got hit just like our main channel did not long ago. It was quite a brawl, as they say, the first time around. Flusha, thank you, $2. Federal fraud exposure train. Thank you. Appreciate it.
Yesterday was a doozy. If you missed Judge Simpson, you missed a lot. You need to go back and watch that. It was a lot of fun.
That's
and very
good that,
exposing, by the way.
Good that happened that quick and easy, and YouTube did the right thing. So,
finally, we win one, but did we really? We got hit with that. So, I mean, did we really win, or did we just get ourselves out of trouble? So,
right, it's a win. It's a win in my book. Anyways, all right, let's jump from here. Where are we going? Over to church or what?
Yeah, I don't even know. It just says it's family law attorney represented docket A. So just a dad arguing with the judge. Maybe if he's speak up. And show us your Pokemon drawing.
Mr. Dunn has indicated that he doesn't have the specifics of the educational proposal, which would be key for the decision here
days
today.
When you've quit.
He's had ample opportunity since at least September or October last year, when the issue was before the court, to supply the court with any necessary information to make that ruling. In the absence of that information,
I think that's what
moving forward on the best information that the parties, who it's their responsibility to bring this information to the court. With that said, I addressed this summer because that's what's looming most pressing.
Is he in the kids' room? Look, it's like
months where the father does not
Ninja
have
Turtle
time with the child.
Curtains.
He can come to Washington anytime he darn well pleases with 30 days notice and have 3 days of visitation with his child in Washington. Transportation, it'll be the closest airport to the parties. Probably going to be the Portland Airport, Portland, Oregon, and whether it's the Hobby Airport or the Intercontinental Airport.
Where's
whichever one will be the better deal. But notice
always need
will
a
have to
gym.
be given to the parties on that. So as far as the party who makes those arrangements, for any time that the child travels from Texas to Portland, basically it's the receiving parent that'll be in charge of making sure that the airfare is paid for and arranged for so that they receive the child into their care. So if the child,
Michael
he's making arrangements for the child to come to Texas, he would make their travel arrangements to fly.
He's losing it, Creed.
Welcome back, Doug. Or
when the
Doug,
mother.
I thought I got rid of you, Doug.
The child gets from Texas to Portland or airport, she would make the arrangements.
Oh, we got rid of all dogs.
Those airfare and arrangements need to be given at
His
least.
dad is having a bad day. Look at him; he's falling apart. Creed.
The other parent upon receipt of the scheduled flights. So that's really important. The child's young. The child needs a chaperone or somebody to travel with him as he travels to and from these locations. And so either
you have to pay for that, right? A chaperone
or a chaperone that travels with the child, so the child is safe and well taken care of. As far as phone and video visits going forward, I've mentioned the 6 days a week.
Whips and chains and like chairs hanging from a ceiling in the basement kind of vibe.
One time a day.
I feel like he's going to snap.
Is reasonable at the same time frame, 6 p.m. during the week and 10 a.m. on the weekends. I think that sometimes there needs to be assistance with a child that young, but there shouldn't be any monitoring. Should be free communication with the child.
Freaking out, man.
As far as it sounds like communication has been an issue of late. So I'm going to order that the parties sign up and participate and pay for their respective service of it's either called My Family Wizard or Our Family Wizard.
We learned that's the thing that keeps up with all the chat logs
about that service by going to I think it's My Family Wizard or Our Family Wizard on the internet. You'll need to sign up and pay your fees within 14 days of today's hearing. All parties are required to provide to the other party, to the other parent, where Joseph is residing or will be residing.
Love our travelers.
3 days of this hearing. So in other words, Ms. Hilton will need to provide notice within 72 hours of today of where Joseph's exact location where he's residing.
It's got Ninja Turtles, Power Rangers.
It's got the same
story.
Facebook group as you.
If the parties move, notice has to be given within 24 hours of the move. Also, with regard to medical and dental appointments that have been made, Ms. Hilton is required to provide notice to the father within 12 hours of making the appointment. And if there are any changes, again, there has to be immediate notification to the father of
it's gotta be terrifying.
And that will allow Mr. Dunn
traveling from Texas to Portland, Oregon,
them request records, and so he knows exactly what's going on with his child, and if he wants to make an arrangement for a video visit so he can participate in that, so be it. So with regard to the winter break that's coming up this end of this year, I'll grant that the father has a visitation with the child every year for 1 week from the time that school is out until December 23rd.
Got a whole plate underneath.
The child would fly back.
You're just sitting there like, it's got to look good. It's got to look good.
Good point, lad.
So
frightening place.
That's probably what he's worried about. Is the kid's going to end up on a
guardian ad litem, and the guardian ad litem's duty is going to be to principally investigate the proposed joint schedule presented by Mr. Dunn, the 120 on, 120 off, and also the educational
show off his kids' stuff, I guess.
Programs that each parent is proposing. They're drastically different, as well as the parenting plan is drastically different that they're advocating for. So that guardian ad litem, I'll ask Madam Clerk if you could tell us who the next 3 guardians that are on the list, and I'll just explain this to the parties if you're
apparently doesn't do a very good job.
3 guardian ad litem's presented to you. Their names.
I know it said ban them. I was like, okay, that's what I clicked.
That you don't want or just.
Oh, did I talk over that, JG? Seriously, is this over 1 week a year?
After you've each removed one from the list,
maybe that's what they only get to see him 1 week a year.
That's true. That's the guardian ad litem that'll be appointed to the.
I never claimed I was a geographer.
So, any questions about that process?
I said Portland, Oregon. I don't know. Portland, Washington.
No questions. I assume you're going to address payment on that.
Portland, Montana.
Geez, Stephen O'Neill.
Mr. Dunn, any questions on that process of the selection of the guardian ad litem?
Kansas City, Florida.
Okay, great. And Madam Clerk, if you could tell us the next.
Yeah, it's like a blanket, right?
Jen Height,
Comforter.
Twyla Corey, Keith Lawrence.
Either that, he's just hung up a
Mr.
curtain.
Brewer, do you have a strike in mind?
Thank you for liking on Bith channels.
I
Nancy.
really don't. I'm not familiar with any of them, so I don't have a strike in mind. I'll leave it to the court's discretion.
Thank you. Mr. Dunn?
Mr. Dunn?
Oh, it looks like Mr. Dunn, you're muted. My apologies.
Overdone?
I'm sorry about that. I believe, Your Honor, Mr. Lawrence.
Carl,
might
did
have
you say
been
you're
the
pretty
guardian
much
ad litem
blind?
on our case
At
before.
one point, didn't you tell us that?
I don't really feel that he did his due diligence of contacting our people until the day before my last trial
you.
with it. So probably
Portland,
would like to
Seattle,
strike
Kansas
Mr.
City,
Lawrence,
Florida.
even though later on in hearing, he seemed to understand a little bit more.
Okay.
But I guess strike Mr. Lawrence.
All right, very good. He's stricken. So having the last person stricken and Mr. Brewer not exercising a strike, I'll
Okay,
appoint
I'll
the
check
first
it.
person on the list, which will be Ann Height. Ms. Height spells her name Hight. Information will be sent to you
Thank you,
by
Todd,
Ms.
sir.
Height, asking for
Appreciate
kind
you.
of some intake and registration information, and then she'll start her investigation. Mr. Brewer brings up the issue of payment of the guardian ad litem. There's two ways we can do it. One is what we call private pay, where the parties pay roughly 50% of her fee each. Or there's what we call county pay if the parties are in a position where the funds are tight and unable
Oh,
to make payment.
look
And
at
there
that.
can be a
You get the
combination
damn.
of those
Do you
two.
say
So,
county pay?
hear from,
They pay for the flight?
Mr.
Yeah.
Brewer, if you have any suggestions from your client's perspective, and I'll hear from Mr. Dunn from your perspective.
My perspective, I'll just apply Clark County. What we do is, I don't think we qualify for county pay in this case, from my client's perspective.
All right, thank you. And Mr. Dunn?
Whichever way is most convenient for the courts to handle this at this point, sir. I'm willing to handle it that way.
Okay. I apologize for the intrusive questions, but Mr. Dunn, I just need to get a kind of a sense of where you are financially with your income on a monthly basis. Can you give me kind of a general idea of what your net income is on an average?
Uh-oh.
I'm a 1099 employee. It kind of ranges between about 2,000 a month right now. Is what I should be able to
Sorry to
bring
get
in.
so personal,
with this.
sir, but
Okay.
You have a
All
big
right, thank you.
tuna?
Right,
We need to
so
know
as far
everything,
as
sir.
the father's fee, guardian ad litem it'll be county pay, meaning that the county will pay Ms. Height's half of her fee, and the mother's will be a private pay, and she'll pay her half.
Dallas
from her
Alice?
funds. So the county will pay Mr. Dunn's, and Ms. Hilton will pay her portion from his.
That's crazy. I didn't know that was even a
Ms. Height
thing.
For her
no,
services.
good for them, right?
General time frame and turnaround times for a guardian ad litem report.
They're paying for flights.
We're here in the early months of 2023.
Yeah,
I'll be smiling here in a
It would
second.
be
I figured
great
you
if
couldn't
we
pay for it. You were
went first
SOL,
part of
right?
February,
Like,
would be looking at April, maybe 2 months from now.
Won't be
to have,
simulcasted, but
the, interim report.
no
presented
simulcasting,
to
but
the
it'll-
parties and to the
Discord's
court,
for.
and then we could
yeah,
set a
it'll be in
date
Discord.
roughly 2 months from now to review that report. And so let me just take a quick calendar and propose a date to the parties.
DM Andy, good to see you, bud.
What's going
April
on?
11th, we
man?
could
Josh-
set a hearing at 9 a.m. to review the guardian ad litem report.
You could always
Does
do
that
that
work
too.
for the parties, Mr. Brewer?
Yes, that's fine.
Okay,
Yes, Your Honor.
done. Okay, great. And I'll
Carol,
just
it's
double check
Supreme
if Ms.
Court,
Height is on the
church.
line right now, she's not. I was going to ask her if that works.
I
for her,
mean,
but we'll set
if
it for
that's
that
what the
date. So
courtroom
April
looks like
11th at
there.
9 a.m. will be the date to review the interim
No,
guardian
it's
ad
not.
litem
It's got to be a
report.
green screen. Gotta be.
I know it's a green screen, but it's
Oh,
got to
but
be a
maybe
picture of
his-
something.
Maybe of
let's
his
see,
actual
it was
court.
Mr. Dunn's
Yeah, of
motion
his
to
actual courtroom.
Bring
Yeah.
the adequate cause and the motion. Oh, no, pardon me, it's your clients. So
Correct.
you'd be in a position of preparing those orders for adequate cause and the parenting
Oh.
plan. Sharon?
Yes, certainly.
Okay.
Doug's
Do
smart.
we should probably set a date for presentation on that.
Doug, you're a very thorough man.
Welcome back, Doug.
28th of February at 9 a.m.
Enjoy being over on
I'm
that channel. with
proposing
the,
that
four
for a
people.
date in which Mr. Brewer would prepare the orders that the court has verbalized here today. He would send them to Mr. Dunn for
believe so.
Mr. Dunn's review. If Mr. Dunn has any concerns related to that, he would file an objection or note where Mr. Brewer got it wrong as far as the court's ruling. So 28th of February, how does that look for your schedules, Mr. Brewer?
That's fine.
Okay, Mr. Dunn.
Should we discuss what he
On
should
your
wear
honor.
tonight on
Okay,
the
Great,
show?
we'll set it to that date, and that'll be on for presentation of the two
You're looking
orders
at it.
And then on April 11th, we'll hear from the guardian ad litem. And then, Mr. Gore, as far as the guardian ad litem order, could you prepare that also?
Certainly.
Great. So we'll look for those 3 orders on the 28th.
I thought they were, no, I'm pretty sure they were talking about the flight.
Sally.
I'm almost sure that's what they were saying.
Oh, 100%. 100%. They're going to pay for the flight, and the mother has to pay for her side of the flight. It's very surprising, though. I didn't think that was even a thing.
I swear his attitude changed after they got that paid. Maka.
It's just remarkable.
Yeah. I think we should start
The pre-launch party for his OnlyFans.
Let's start this Saturday, the 11th,
Okay.
with the Zoom visits and get those started this week.
All right, real quick. I'm going on to the show. It's called Tech Troublemaker. Okay. You can find it on the YouTube real easy. 9:00 tonight, Eastern time. I'm going on there, and we're going to talk about how this channel basically started, what we had to go through to figure out
all
the things we did,
continue to do wrong, and will continue to do.
Yeah. The dealings of the daily in and out of everything we do around here. It's basically like the ins and outs of the behind the scenes stuff, as well as I'm sure he'll have questions about how we do things, but to be honest with you,
matey,
we're going to be doing it wrong. Because we do. We're doing everything wrong. So his channel
is basically helping out people do things the right way.
Right. He's giving advice. He's giving, tech talk, that kind of thing. It's to help people, that don't know what they're doing. And, I'm sure he wants some backstory and stuff. We'll delve into all that. Most of you guys know everything about that. But
I commend him for having you on and to talk about abnormalities, if you will, of doing things.
And I guess multiple channels is really not a lot of people do that. I guess they're not dealing with
not
more
a lot
than
of
one channel.
Yeah, but not a lot of people do more than one thing. You stick to one thing and you do it, and you do it well, and you don't divert from that. And that's part of why a lot of people get stuck and they run out of things. You look at a lot of these resellers that have their channels, giving you fake information on how to sell things and where to buy it and all that. You run out of stuff after a while. But yeah, there's not a lot of people that do a lot of, we'll say a plethora of things, but I think it'll be fun.
And the amount of time that me and Creed are on every week. I mean, I told him how many shows we do a week. I said, typically with nothing live happening, at least 12 a week. And he was just like, 12 shows a week? Like, yeah, 12 shows a week.
Yeah. Plus a couple extras here and there. And
yeah. Never know what's coming up.
Anyway, so I think that'll be fun. I'll be looking forward to that.
Here on behalf of the moving party,
we got Michael here now. Michael is creepier than the last guy.
Your Honor, there is a preliminary issue. I've not been provided with a notice of hearing on the spousal support issues. I know that a financial declaration was sent to me on Thursday.
Spousal support.
I've not had any notice.
Maybe he'll do a walk by for you.
Yes, on the issue of my temporary protection order, but I've not been provided with this, and I don't have any notice of it. That's the first issue.
He has a medal.
The second issue is, and it's important for me to bring this up to the court. This is the third.
Chad's working over here
before the court, based on the same
I
matter,
see ya.
due to myself not being able to get the material that I needed in order to proceed forward. We had this temporary protection. This temporary protection order. Sorry, my apologies. This temporary motion for temporary family law order before the courts. It was continued due to the fact that we did not receive a response from Ms. Turner. We then scheduled it for a second time, and it was the same scenario.
By the way, spousal support. I'm all for child support, but spousal support is one of those things that I'm kind of on. That you continue to keep your wife or husband, either which way it goes, in a certain lifestyle. And that's tough. And Michael's having a hard time already. I can see it with his face.
Dr. Green Thumb?
Issues of the spousal support and concerns therein.
Agree.
We don't have a notice of hearing on that. So I'd just like to address that before we move forward. Thank you.
Okay, thanks. Mr. Reed?
Your Honor, I'm not sure what Mr. Mears is trying to do. I feel as if he's just trying to point out flaws in our procedure, but it has nothing to do with pushing this case forward. If his sincere concern is to address the issues, then let's address the issues. I feel like we've had several issues. Mr. Mears,
I wish we took out that sponsorship for men's hair
a
growth
declaration in this last week in this case, which it was also equally confusing, complaining about the clerk's behavior towards his staff. We have had similar issues. It has been almost impossible for us to file certain things in this case, but nonetheless, Your Honor, we're ready to proceed on this. This is a seriously dysfunctional family, and they need some support here. If Mr. Hamir is complaining that we didn't file a notice of hearing on our motion, fair enough. We didn't file a notice of hearing on the motion. We intended to get the motion on the record, knowing that there's at least a hearing in this at this time. We noted that Mr. Day's motion did not include anything about a GAL in this case. It did not include anything about spousal support.
Congrats.
Both of those things are really important in this case. As Your Honor noted, it basically Mr. Day's motion basically runs the gamut of what we need to cover in a family law hearing. I don't think there's any deficiency at this point in what we're trying to do. We just need to have this case heard.
And if I can respond, Your Honor.
You can. Let me just.
Oh, my. Look at you. Get some Australian monies from the future. Appreciate
Australian money. I wonder what that's worth.
I know it's worth.
Come on, be higher than the dollar.
At least this much. God bless Australia.
We appreciate your patronage.
I noticed that my staff had inadvertently filed that our motion for this hearing in that docket instead of in this docket. We refiled it again. I think it was a week ago when we discovered that there was an issue. Again, Your Honor, we didn't file a notice of hearing attached to that motion. It's simply a motion that was filed with the court.
Thank you, Mr. Hamir. Your initial motion.
Yeah,
so I guess January 26th.
I'll let you know when
there's
we
a
get
motion
it.
by Mr. Reed
open air
that was
sniff
filed
on the street.
that raised the issue of support on January 26th. So that one, you're saying that there is not a notice given to you related to that for today's.
That is correct, Your Honor.
Does anybody here in the chat right now receive spousal support?
I do not have anything with respect to that. We're ready to move forward on the temporary protection order. I mean, sorry, I keep saying temporary protection order, but I'm ready to move forward on the motion for temporary family law order.
Yeah, let me ask you, Mr. Hamir. It looks like Mr. Reed filed on behalf of his client, Ms. Turner, on January 26th,
right.
A motion for temporary family law order and restraining order, and paragraph number 5 indicates that they're asking for child support and asking for spousal maintenance of $1,200 per month.
My client has no objections with respect to the child support, as he feels that that's warranted. But with the spousal support, we do need some time to review it. We were just provided with the financial declaration on Thursday evening. I think it was like 5:15 that I was.
I think Mr. Reed's the attorney. I don't know.
We can move forward on it today if it pleases the court. But again, I want to err on the side of caution and make sure that my client is not prejudiced in any way. Based on the fact that we have not had the opportunity to, sink our teeth into it. We've been working with this motion for temporary family law order and the responses therein, and we've been scurrying our whole entire office has been scrambling.
You just made a great choice.
Decisions.
I can see that there's been a lot of filing going back and forth over the last week. We keep putting this over.
You know what,
Creed? Putting this off.
I liked
week by week
Kumar a lot better when they were looking for White Castle.
Yeah, when he was an actor,
with our busy schedules. So that's That's one issue, and we're doing, and I agree in all credit to Mr. Reed, I know he's doing the best he can to get these matters filed also, but we are running into an issue in where if I don't have the proper documentation in time, I can't give my client effective representation. So with that said, we are ready to proceed on the temporary protection. I mean, again, the motion for temporary family law order and the
He keeps saying temporary protection and then
the details entailing that. We're also
is he trying?
have no objection to a guardian ad
seems
litem.
like subliminally keep putting it in mind like this lady needs protection from this guy.
Is he doing it on purpose? You damn genius!
If it's in the best interest of the child. And with
Mind
the child
freak.
support, we don't have an issue with that. Also, thank you, Your Honor.
Well, at least
Please
that's
note that the January 26th pleading filed by Ms.
well done, Carol.
Turner raised the issue of child support and also maintenance. And I see that the reply declaration from Mr. Day, thank you, indicates that he's in opposition to the spousal
Mr.
support.
Day.
And he wants to support his child through child support, but there wasn't any worksheets for consideration. So, I think it's the initial concern was that there wasn't notice provided about the spousal maintenance. Looks like the proper notice has been given, and there's actually been a reply. The issue of the child support worksheets not being provided, I don't think for me is a huge issue in that we can address incomes, we can establish incomes, and then we can input that into the worksheets and kick it out.
Flipping good.
Issue
Good
of
to see
spousal
you.
support
Good to see you, Ben.
or maintenance. The concern there is that the financials were received at maybe a later time on Thursday. I think last week was the indication. So I think what we can do is we can hear all matters and then we can address the maintenance once there's a more precise response to the financials. So we can address it, but I'm not going to give a ruling on it today because we'll get a little more information. But we'll address everything else today, and then we can hold off on the spousal maintenance for just not a long time
Spousal
in the future, but
maintenance,
shortly
Creed.
thereafter.
I like that
That
one even
being
more.
said, and
Spousal
rule upon,
maintenance.
I'll ask you any additional items.
Gotta
where
keep
the
her
parties
oil
need to have
changed,
you
tires
before
rotated.
we hear the argument from.
Keep the insurance good on her.
No, thank you, Your Honor.
All right, great. So we're here on, pardon me, on Mr. Day's motion. So we'll hear from Mr. Hamir, please.
Thank you. May it please the court, Karim Hamir, once again, Mr.
No, I thought we
Day
were
is present
done.
with us.
Jesus Christ, we're just
My
getting
client
going
is
here.
requesting
It's
a
getting tuned up, I
modification of is requesting a change in the
foreplay, I
parenting
guess.
plan based on events that have happened over the last several months. This started off with the relationship that in where my client and Ms. Turner have been together for over 15 years, and in some way, shape, or form, they've been together. Things have turned extremely sour, and a temporary protection order
No
was
shit, did
was
it?
filed by Ms. Turner against my client, and in that case, Ms. Turner was failed to establish by the balance of the probabilities that a temporary protection order.
Oh, she
was
tried for a
warranted.
TPO and couldn't get it.
Subsequent to that, my
Maybe
client
that's
did
why he kept
have
saying that then.
a relationship with his child and was unable to do so. He had come to the house on a couple of occasions to meet with this child, and it turned out to be quite a contentious and litigious circumstances. As a result of that, my client is not. My client has provided a motion for this protection order. When we did provide the motion for protection order, the response indicated some allegations on my client that are categorically and untrue, and we have provided as much evidence to the best of our ability to refute those allegations. My client's main concern, and a couple of the issues, or three of the main issues that my client is trying to get across is Ms. Turner has by my client is alleged to have
That made me laugh.
significant use
Call me
of
sweet.
non-prescription
Call him
drugs
sour.
along, using
Sweet and
marijuana.
sour.
Sweet and sour.
And not only that, the allegations also include and asserts, my client also asserts that Ms. Turner is using marijuana while her child is in the car. And as a result of that, we're requesting that and we're moving for that all the non-prescription drugs from the household be removed, and no driving while under the influence of marijuana or any type of similar types of intoxicants, drugs, or alcohol.
Can they do that?
my
Ask for
client
the
is also
prescription
requesting that the
medicines to be
marital
removed from the
residence,
house?
which is going to go on
Nobody's
sale,
trying, I guess.
which we are trying to get it on sale in order for the dissolution of the marriage, that we tried to get this on the market, and we cannot do that when there's third parties that are living in the premises. There are two concerns here. The first concern
Also, I think they partied
is that there's an
together, too.
adult
So-
renting out a room in the premises, and my client does not know who that is. And as a result of that, we don't believe that it's in the best interest of the child. My client also indicates that there is it's a transient style circumstance in where someone is always constantly going in the room and moving,
That's not good.
either living there or not
That's the
living
case.
there, and it's like a revolving door. So we're requesting that that no one lives in the house until for two reasons: for the safety of the child, and secondly is to have the house sold so we can move forward with the actual dissolution
Time to
of
get
the
out.
marriage. Also, my client is also requesting that due to some of the erratic behavior that has taken place on behalf of the
Non-prescription,
client,
I'm sorry.
along with the phone calls to the police station, the police officers, and some of the acts that have been done, my client is requesting that
Like what?
that Ms. Turner go
Kareem.
through an alcohol evaluation and follow up with subsequent recommendations by the alcohol evaluation.
That one
So
made
those
Mr.
are
Reed
the
laugh.
three main concerns. The other issue is that there's an allegation that my client does involve in the use of illicit drugs or alcohol or what may
Or
be.
That's
during
good.
sex,
My
I
client is a subcontractor for the federal government. And
No.
he gets tested at his office, at his work all the time. And he does not refute, and he does not have any issues with taking any type of drug test at any time, as long as Ms. Turner is on the same footing. Thank you, Your Honor.
I like
Great,
that.
thank you. Mr. Reed?
What you got, Mr.
Thank you,
Reed?
Your Honor. Your Honor, I've been frustrated in this case by Mr. Day's responses more than anything else. He was accused of breaking into the house several times, and in his response, he expresses a dangerous arrogance. He basically says, yeah, he can break into her house anytime he wants because he can, because he happens to own certain bundles of sticks that give him the right to own the property. Does not mean that he has the right to be in the property.
Weird
He has not
analogy,
lived in
but
the home
okay.
in more than a year.
Yeah.
There was a protection order. It was dismissed because Ms. Turner had difficulty expressing what her fear was based on. And he immediately, within the hour after that protection order was dismissed, he immediately went back to the house. He invaded her home and her privacy. She
With
felt
sticks?
threatened. She called police because she felt threatened, but he claimed because he owns the house that he has a right to be there. He then expresses in his own declaration how he on a weekly basis, he methodically
Spoiler
came
alert.
back to the house that he does not live in, and he broke it. He broke down a door, he broke through a window, he broke
Damn.
into the house and invaded her home. The
With
hubris
sticks?
that he expresses is
Well,
shocking.
he had a bundle,
In
so
this case, he believes that because he has some ownership right, that he may have some ownership right over her and her ability to live in peace in her own home. He even expresses in his declaration that
he's a
he
dominatrix.
had considered fleeing with the child and taking the child to the Tri-Cities area, which would be completely inappropriate. The parenting plan that he proposes is full of 191 restrictions based on what Mr. Hamir claims is her erratic behavior. However, her
It's busted in.
behavior is not based on substance issues. In fact, there's no evidence that has been provided anywhere that she has any kind of substance abuse issues. It's based on her fear of him. I can understand if the man that you have that has admitted to sexually assaulting you has broken into your home on a weekly basis, it seems reasonable.
Objection,
that you
Your
would
Honor.
Be fearful, and that you would behave.
Speak up, Kareem.
In
Michael's
a way
talking
that
real
makes
close to
him
the camera.
uncomfortable.
He went to
If
the
he had
Bishop
been
School of
tested about
Broadcast.
his
He sure
drug abuse, we have no results. We haven't seen any. His complaints about what is going on in the house was based on information that he knows nothing about. Again, Your Honor, he has not lived in the house in a year. He has only come back to the house because he can. His proposed parenting plan contains all kinds of restrictions on her, suggests that the child should live with him on a permanent basis with only very limited phone calls from mom, the mom that the child has been living with only for at least for the last year. It's fundamentally unreasonable, his proposal. We do propose that there be a GAL. We certainly believe that there should be financial support in this case.
In the city of Washington,
at least child support. The financial declaration that we provided indicates that Mr. Day has a gross monthly income of approximately $7,500 a month compared to an imputed income because Ms. Turner has been a stay-at-home mom. He has required that she be a stay-at-home mom. He has not allowed her to work. So she had no work experience.
Eric?
He when he stopped providing his
Where did he
monthly
find
support
her
when this case was filed? He stopped paying utilities. He unilaterally decided
online.
that
She was looking for a
child's,
sugar daddy. I
phone
don't know.
needed to be cut off. Meanwhile, we have had to file multiple times, try to file restraining order against him for his erratic behavior. He unilaterally decided to put the home on sale. That is something that hasn't been discussed among the parties. Not really
Put the home up for sale while she's still there.
You walk outside a big for sale sign.
It's just indicative of his belief that he has the right to make all the decisions in this case. And
the attorney just said she has no job experience. So that's why I'm wondering
that he doesn't have.
Where did he find her with no job experience?
For all these reasons, Your Honor,
more to this case than I had
child
expected.
bride.
Pray that the court would find in our favor.
Thanks, Mr. Reed. One quick question. I was under the impression that the house was for sale. Is the house currently not listed?
Maki. Good to see
Your
you.
Honor, if you have that impression, then I may be mistaken on that. I don't have that in front of me.
I can put it up, Your Honor.
Thank you, Mr. Reed. Go ahead, Mr. Hamir.
The house is not for sale. And I believe, according to my client, that there was an agreement to sell it. There wasn't an agreement to put it on the market, but there's an agreement for sale. And I believe that the reason why they're doing that is to avoid foreclosure because the client, my client has to pay a lot of bills. So it is a marital home.
Thanks. Any rebuttal to the argument presented?
Yes, Your Honor. My client has never been, and again, I objected to it on the record, but I'm going to just bring it up again. My client has never sexually assaulted anyone, has never been convicted of sexually assaulting anyone. You know, I think that it was a complete misunderstanding, but that's my client is categorically, unequivocally denying any type of sexual
misunderstanding. How do you have a misunderstanding about that?
And if there was something that was against the law, then the police would have taken a different measure. The reason why my client states that he has not broken into the unit. What he did and what he's entitled to do is see his children that he doesn't get to see. He's always being restricted from seeing his child. He's doing what any father would do, wanting to see his daughter. And that's what his intention was. He has frankly, he's moved on with his life and he doesn't really have any concerns with respect to Erica Turner, and it has everything to do with the child. Thank you, Your Honor.
Nate, good to see you, bud.
One point of clarification. I just want to make sure the parties are aware what I plan to rule on. I plan to rule on child support. I plan to rule on that the home sale, whether a person can rent there. I plan to rule on a parenting plan. I plan to rule on debt.
God, he's
some
doing
debt, not all of it, but and also property today. Parties comfortable with me proceeding?
By the way, do you guys think that he just hasn't been paying the mortgage on the house so he could sell it and kick her out and claim that he didn't have the money? Because that's how I feel. I could be completely wrong though.
Child support. Callista is sounds like a wonderful 7-year-old. The father has looks like he makes a fairly decent money. Money doesn't go as far as it used to, certainly with all the inflation and the like. But it looks like I'll set his gross at 85.42 per month with a net of 71.63. So a gross of 85.42 and a net of 71.63. As far as the mother, looks like her work history has been limited to various factors. So I'll impute her at full-time minimum wage for the mother. I'm not sure what if there's insurance that's being paid out for Callista from the father's insurance policy. If there is, he should be given credit for any payments made for Callista's health insurance. As far as maintenance, I'm going to pause on that until I get more information from the parties. It could be certainly noted up. The family home, at this point, it was purchased during the marriage. The parties have separated. There's some not insignificant debts that one related to the home and other debts. There was some discussion apparently from the parties as far as the selling of the home. I think with the debts and the like, I think that the home needs to be put on the market. So the parties will need to work together to choose a realtor.
Sounds about right,
that is,
Andy.
agreeable to them both. If they can't agree, then we can address it on the maintenance. When we're back on the docket here, the maintenance issue, and the court can appoint one of the parties' choices.
I see that.
Then if, as far as then in the interim, there's concern raised about the that's within the home that's paying a certain dollar amount to rent that home. Mr. Day indicates that he's uncomfortable with that for two reasons. One, for safety of the child. Two, doesn't necessarily help a home be sold. So I think given the current situations that the renter can remain in the home, but has to comply with any efforts of the realtor to present the home in a proper fashion, that the realtor.
Don't you wish every divorce was like that? Like it was cut and dry, that simple, and not all this? Because this is a lot. This is a lot going on with the renting of the house and the guy that's living there that might be, I don't know, honest boyfriend. I don't know. The lady doesn't have any job experience. It's going to be a time. But if this house is worth anything, they should do okay, I would think.
The home is sold, the mother will be in charge of paying those utilities. There's some debts that I think can be properly addressed with the sale of hopefully there's equity within the home. That's my assumption, but I'm not sure. I'm making that assumption. The parties can divest me if that's an erroneous assumption. There's the Northwest Health debt of roughly $6,000. That's apparently the smoke detectors that were installed in the home. That should be paid with proceeds from the sale of the home. The Capital One bill of roughly $7,500. I believe that was the roof repairs to the home. Again, since that's so closely tied to the home, that should be paid from the proceeds of the home. There's the IRS debt of roughly $9,000. My understanding is that debt was incurred during the marriage, so therefore it's a community liability. I think that's, since it's such a significant dollar amount, that should be satisfied through the payment or proceeds from the sale of the home. So the indication is that there's an
that
RV
renter could really make this
best efforts.
Oh, it can make it
Same
real
with
sticky.
United Finance of roughly $16,000. That'll be a best efforts to pay that. I'm not assigning one party or the other over to address that. So as far as the property, it sounds like the parties have pretty much divided the property. I know that there's some dispute as to some personal property items, but the truck, the Dodge truck, the father will continue to maintain possession of that and pay it.
I know. I thought that was weird. I don't know.
The mother's car,
they owe money to the IRS, and
she will continue to possess that and pay the monthly payment on that. I recognize there's some dispute as to the origins of the monies that made that payment. If there's not a payment, then mother will continue to have possession of it. There's the Wyoming property that there's probably much more that needs to be delved into there. At this point, it's not to be sold. It's going to be addressed.
Yeah, Stephen, Mikey said that earlier.
Certainly, if the parties come to an agreement and there's a buyer, the parties can ask if they're agreed, then they can move forward and sell it. But it can't be unilaterally sold. As far as the firearms, there's an indication that the mother has possession of firearms, and it sounded like the father was not in opposition to her selling those and splitting the proceeds equally between the parties. So I'll order that. There'll need
Nothing
to be
like
proper
your ex-wife
documentation, so
going
everybody
into the
feels like
gun
there's,
selling business.
the bid or the offer is known and the acceptance of the same, and then transmission of the dollars should be documented. Whether
Is
that's
Michael in
through
pain?
email or written document, I'm not, don't care either way.
Or
There was
confused and
concerns about
constipated.
the private school and the tuition related to that. It sounds like the parties, while they were together, and then
I'd imagine the one
I'm
house
not
is worth a
100%
pretty
sure on this,
penny.
but it seemed to me that they had made a decision to send Callista to that private school. Father
They're
has some
sending a kid to a
concerns about
private
the
school? You
education
got money
there.
like that?
At this point, I'm not
About
going to make any
$7,500 a
changes. It
month.
sounds like the child has been there for at least
They're
a
already
year,
in, Bill, I think.
if not more. And then the percentage of that
Oh yeah, they in jail,
tuition,
prison already.
the payment of the tuition will be based on a percentage of each party's income based on the child support. As far as the restraining order that's been requested, look, I get the idea that two people own a property and that there's
Toy
a
Mom?
legal right to enter
Hey,
into
Toy
one's
Mom.
property that was obtained during the marriage. It's a wholly different matter when there's kind of this manifest insensitivity, running roughshod over expectations of privacy, and I'll say even lack of basic respect of entering into the home and using a force to enter into the home. So there will be a restraining order that prohibits
Kicking the door down.
Mr. Day from entering into that former marital home. And he'll need to stay away from it by a distance of 1,000 feet. He's
Well,
allowed to
he
be-
finally made that judgment. I didn't
in
see that
addition,
coming.
That
Slightly.
yeah, so that'll be that. Then as far as the parenting plan, there was a request of a kind of a tiered approach by
Yeah.
Ms. Turner. I'm not exactly sure the necessity of that, so I'm going to hold off on to that. I think there is a limitation that I will impose on the parenting plan upon Mr. Day related to domestic violence. Domestic violence doesn't necessarily need to be physical contact between two humans. It can be the breaking of a door or a window to enter into a home with past concerns of either abuse, emotional or
Stretching it there,
verbal
but
or otherwise.
I didn't know that.
So the mother will be.
So that'd be like if you got mad at your wife or
father-
husband and knocked the glass off the table and it broke, or the classic punching of the wall or door, are all considered domestic abuse.
I didn't know that.
I
wonder if that's a state by state thing or if that's a.
I've never heard that, and Kumar made a face when he said that too. Oh, the absolutely. Are you kidding me? Come on now.
Yeah, I'm pretty sure of that.
He's nailing the rail.
PM or a grocery store, somewhere where that there's a constant and regular flow of persons. If anybody's going to be later than 15 minutes, you need to give notice of that tardiness as soon as possible. As far as the concerns related to drug and alcohol, I think that there does not need to be any evaluations. However, everybody will be kept honest if there's when the parties have residential time with the child, if there's concerns that that one parent has consumed either non-prescription medication or marijuana or alcohol, the parties can ask the other party to submit to a urinalysis, and that has to be complied within 4 hours. If the test comes back that there's no issues, then the party who requested it just eats that cost. If it comes back that
Did you just say the kids basically got to get drug tested?
Marijuana in the system or alcohol or other non-prescribed medications or drugs, then the person who tested.
You know what I think
positive
about
for those
that?
will have to repay for the examination or the
never forget.
analysis. I think that's provides a degree of safety to the parties and to the child. Obviously, any cigarette smoke or marijuana smoke around the child should never be exposed to any of that. So any
Cigarette
party
smoke
who
and as
either
well,
smokes,
Creed.
either tobacco or any other substance or marijuana.
My kid's
is
never around
explicitly
when I'm
prohibited from doing so while in the presence of the child, whether that's in an enclosed
God.
facility
This
or out in the open.
Judge would have been
just
around when I
don't
was
do
a
it
kid.
around
He'd
the
have put
child.
me in foster care.
As far as the there's been concerns raised related to romantic.
How many times I
interest
accidentally got
exposure
burned by a
of
cigarette?
those romantic interests to the child. At this point, I'm just going to impose a 6-month moratorium on introduction of romantic interest to the child. So in other words, that there's to
Oh
be
my God,
zero
ruling on
introduction
that
of
too.
conduct
He's
of
already
romantic
living there,
interest
dude.
until at least 6 months after the relationship is commenced. I think that provides a safeguard. protection of the
Who's that
child.
guy living in the other room? I can't introduce you to him
As
yet. I'm
far as
sorry.
attorney
Yeah,
fees,
he's
I'll
nuts.
impose and
Just
require payment of
avoid him if
$2,000
possible.
from father to mother for attorney fees. And the issue of maintenance is reserved. One thing just on the
Maintenance.
family home, there's not to be any waste or damage to the home. So all parties need to be very careful about preserving it in its best condition.
As did
The-
mine.
Yeah, I think those are all the issues that I had raised, and the parties may have additional items. Let me make sure. Oh, decision making. Decision making
Enjoy, Andy.
Take care, Andy.
is interesting in this case in that there's what I consider to be evidence of control of one party over the other. There's indications of the
Wow.
entering into the home with lack of due respect. There's indication of the parties had decided to
Yes,
work a certain way as
absolutely.
far as one party working.
Every
not
window
working.
Backwards
rolled
That
up
may
as
have been
tight as
divorced, that may have
possible.
been
Sitting
perfectly
backwards
agreed
in the
upon.
back of
I'm
the
not
station
sure.
wagon.
I think right now that the trust between the parties is probably lower than maybe it's ever been, just because of what's happened recently with the entering into the home and the like. So as far as education and medical, I do believe that there should be joint decision-making related to that, as well as extracurricular activities and yeah, so we'll just leave it at that. So that'll be joint decision-making.
Your dad don't want you to play
And then summer
softball.
timeframes, each party should have 2 weeks of uninterrupted time during the summer to spend with their daughter.
Boy, this
Those,
judge is
the
thorough,
father
man.
should
I
give
give
his
it to it.
notice
He is.
by
I'm
May
impressed.
1st of his desired times of the weeks. The 2
These are
weeks
not
uninterrupted.
easy decisions to make
So
at all.
I'll turn to the parties. I don't have anything more to share on that, but I'll turn to the parties if you need clarification or repetition of anything that I may have shared.
He kind of backed off of that one pretty quick, didn't he,
Sure,
Fletcher?
yeah,
He started to
Can
explain
Amanda
it.
first? Guardian ad litem, Your Honor.
You're seeking an appointment of a guardian ad litem on behalf
I
of.
believe it's the most appropriate, given the circumstances, Your Honor.
Okay.
And it's a request, I believe it's a request by both parties, if I'm not mistaken.
Mr. Reed, is that
What-
true?
What is
It
that
is,
he's
Your
asking for?
Okay.
Guardian
Let's-
something?
Let's do that.
Yeah,
So I'll
anybody know
appoint
what
a
that
guardian
is?
ad litem in the matter.
Ad litem.
So we've got the 3 next individuals on the guardian ad litem list, and Madam Clerk, if you could share those 3.
Lila Corey, Keith Lawrence, Amy Turnbull.
All right, and both parties have opportunity to strike one of those guardian
guardian
ad
ad
items, and if both
litem
are exercised, that'll leave
conducts
us
an
up to one guardian ad
investigation
litem. So the
into matters that might not be brought before the court by the attorneys representing parties, not the child's custodial guardian or the attorney. Ad litem is Latin for the suit.
So it's like the kid's attorney, kind of?
I guess so, yeah.
Somebody to listen to the kid, let the kid.
Interesting.
So without any strikes being,
There you go,
this
you
is my
guys
normal
already know.
practice, without any strikes being levied against any guardian ad litem as far as those proposals, I usually just go with the person that's on the top of the list.
Bassmaster
So that's what I'll do
Hagster.
In this case, I'll appoint Twyla Corey as
Bass
guardian ad
fish.
litem.
He's
As
the
far as
bass
pay-
master.
As far as the mother, I'll make her portion a county pay portion. As far as the father, that'll be, his portion will be private pay.
And just for clarification, my client is confirming that Callista, the daughter, he's paying for his health insurance, her health insurance.
Great. And yeah, if you could, do you know the dollar amount at this point?
I can find out.
Well, it sounds like it's readily available. It
By the
sounds
way,
like
Kareem's
client
voice
is well aware of that, so he could share that with
little
you,
bit
and then
like,
Mr. Reed.
Kumar or Harold.
Get that
Yeah,
worked
he's
into the
nailing it, man.
orders. Okay, so that's the court's ruling, Mr. Mayor. You were the moving party. As far as presentation of orders, if the parties don't come to a particular agreement, we could set this for presentation in 2 weeks, or do you need longer? I'm looking at the 21st.
I'm in trial that day, Your Honor.
Okay,
I'd be
would the
interested to see
28th work
what
better for the parties.
he has to pay in maintenance. You
That'll
know,
work for me. Your Honor.
spousal maintenance.
Okay.
Yes, that would be fine. Thanks.
Perfect. We'll set it for presentation on the 28th of February at 9 o'clock. Do the parties want to go ahead and set that for the argument on the maintenance issue?
Yes, thank you.
Get me a grilled chicken.
Seems appropriate.
And I'll take some of
That's
the
fine, Your Honor.
tortilla soup,
Thank you.
please.
We'll set it for those two purposes, the maintenance argument and then
And
also
maybe
the
kids' nuggets
presentation
also.
on today's orders.
Chick-fil-A
Let
sauce.
me
on
ask
side,
parties,
please.
any additional items, Mr. Reed?
Yeah, just one thing, Your Honor. We still need to work out the child support worksheets. One question that will come up is what the starting date for that is.
Thank you.
Wow.
The motion was filed
So they still got some work to do,
back
but
on
that was
a while.
that could have been quite a mess. This judge, he's damn good at what he
November?
does.
He's
I'm
very
pretty impressed.
evenly toned,
Yeah.
which sets the
Okay,
precedence
so-
of like, we're not going to get upset
So
in here.
since
We're going to
the
be calm the whole
motion
time.
on the
Yeah,
child
we're
support
gonna-
was
Okay,
heard
that's how
today,
it's gonna
I
go.
think that the
Together.
child support should start on February 1 of this year.
February 1, child support.
Any other points of clarification or questions?
Nothing for me, Your Honor.
No, thank you, Your Honor.
And
We'll
even
we'll
those
see the
lawyers
parties on February
played well
28th. Thank you
together.
very much.
Thank you, Judge. Thank you. Thank you, Mr.
They
Reed.
threw
Thank
out
you,
some-
Thank you,
counsel.
Mr. Mayor.
threw out some pretty good.
Okay, so at this point, I believe that's all the
Allocation.
cases.
Yeah, it's a lot was going on and a lot of moving parts. And we don't typically sit and watch anything like that.
No, that
So,
was
you know, to broaden our horizons, to make sure we're like big kids and we're learning every day, we decided,
Yeah.
we were going to give that a try. Let's see what Mary's up to. What's Mary doing?
We were going to have presentation of the order on case number, sorry,
It's okay.
Got a real flower next to Mary.
That's a real gray
Yeah, that
streak in
case
her
number
hair.
would be helpful.
yeah, it's 213
Body rate. Look.
0057008. The
She said,
English
"Let's give
McFarland
'em
case.
something to
I
talk
just hadn't heard
about."
anything from Ms. Cohen, and I thought that presentation was this morning, so I might be mistaken.
Okay,
He's a
yeah, let me take
master
look. I'll pull-
carpenter,
I have
wow.
it here, so let me just pull up and see when our next dates are.
That's what keeps him calm is all that woodwork he does.
They
This is
are
his
just
garage.
they're just talking right. Yes, that's right. They're just talking some dates. Check in over here. See what's going on. We got a few more minutes. Creed needs to get back to his
direction to
eBay.
get some things going with Adam. Looks like Over Health, I guess, is their new name. Looks like you got that going. You're still
Weird,
doing
dude.
your cognitive consultants, and looks like you're doing pretty well according to your PO. What do you think?
Pretty well.
Yeah, it's moving.
Okay.
It's moving, Creed.
All right. I see that finances are still an issue for you. But as I told you, as long as you're trying and you need to finish up your counseling and things before you
Making
worry
about
about paying us, I'm
25,
accepting of
100 a
that.
month
That's
now.
fine by me. Anything else that's in your way of successfully completing?
No.
Man, a few
Since
words.
you're now doing
Yes,
what
very
is asked
few.
of you, your probation
Got nothing to
agent
say.
did not recommend that we have to continue doing review hearings. So this will be your last one with me unless something comes up. So you're all set with me, Mr. Malone. You just continue to report to your probation agent, okay?
All
right,
right, it's moving.
thank
It's
you.
moving.
All right, have a good day.
It's moving, Creed. It's moving.
Yeah. No. They quite the
No.
cast of characters in and out of here. I'm not exactly sure what they're doing. This guy walks up
On the
after
record,
everybody
State
with his
Michigan
laptop.
versus DM Marcel Skinner, 2102844.
No.
Andrea Perry on behalf of,
Raleigh on behalf of Mr. Skinner, who is present to my left.
and you are Deanne Skinner. All right. Today
Mr.
is
Skinner, where's your mask?
probation violation hearing. As a reminder,
Amy R,
Mr.
11
Skinner,
months.
you entered your
Boom.
probation
11
stage
months,
into an
mama.
offense punishable by up to 93 days in jail, I believe. So if you're found to have violated probation, you face up to 93 days with credit for any time that you've already served. also have a special status. If you're found to have violated the terms of your probation, you could lose that special status and have this crime enter on your public criminal history.
You know what?
And I think we need to address, Mr. Raleigh, your client, actually, one of them is a mandatory.
We could have a wire
revocation,
from here
offense,
to
so I
here
don't
just
know
hanging.
Figured out what we're doing with that,
Right,
but
Mr.
nonetheless, come back to
Hold on,
that. You
sure.
have the right to have an attorney. Mr. Raleigh is appointed to represent you. You have the right to have a hearing where it must be proven by a preponderance of the evidence you violated your probation. There are 2 technical violations: failure to report to your probation officer December 20th.
Huge fan.
And technical
You guys can have that
violation, failure to
conversation
enroll
in
in
private.
domestic violence counseling. Mr. Raleigh.
Where do
how
I
are we
start?
doing today?
Mr. Skinner, would be. prepared
Remember, I
to
was a
present
young
your
boy,
guilty plea.
and-
However, respectfully, we would request delayed. sentencing.
Times were different back then.
Well, if you enter
That's all
the
we talk
guilty
about
plea,
now.
as I said, I
Tech
have to revoke that
troublemaker.
status. Delaying sentencing won't fix it. So do we want to adjourn the hearing?
If we could do that, definitely. Yeah. He has already begun to address the underlying issues, Joe.
What are
I mean,
the underlying
if he
issues?
corrects that one, maybe Mr. Hanna dismisses the one, we plea to
Drugs.
the other, and we move on with life with special status intact.
Certainly, that would be,
Is that the goal?
yes.
Okay. Can we adjourn this, February 28, 1:30?
That's 3 weeks from today.
Yeah.
Okay. Yes, thank you, Eric.
Okay.
Odd placement of the plexiglass, by the way. Like
You
just
know,
That
round.
gives you a little time to figure out if you can get this back on track and
maybe they ran out.
Hannah to dismiss the violation. Okay.
Maybe the
And
judge
then
tries to
the bond, I
breathe
said
straight
the
ahead.
arraignment is continued. Anything else we need to address today for Mr. Skinner?
Not on behalf of. Nothing further. Thank you.
Okay, Mr. Skinner, you got 3 weeks. Do you know what's on the line?
Yes, yes, sir.
All right, Mr. Horns is gonna hand you a court date and then you can go.
93 days is on the line. Creed.
Walter,
Walter, just in time.
to say goodbye, basically.
Pretty much. Today is Taco Tuesday, by the way. Hopefully you're enjoying a delicious taco. If not, you can join us for We Got a Chase. Well, we will celebrate Taco Tuesday right there with you.
There, James.
We're heading to South Africa for a couple of chases today. So
South Africa, really?
Yeah.
Okay.
So it's going to be a little different, 2 of them at least, but some really good stuff. It's going to be a good time. Good time.
Well, let's see if we get one more contestant here.
Come on, you can do it, fella.
Through. If not, we're gonna say goodbye, Terminator. She also brings gum to share, though, too, Lisa. So there's that.
She's a troublemaker, like tech troublemaker tonight, featuring myself, where I'll be talking about me and Creed.
And make sure to share those chicken tacos.
Oh, chicken tacos.
Versus James Eric Mills, 2-1.
Chicken tacos can either be really good or just.
Graham McCray appearing on behalf of the people.
Jacob Raleigh on behalf of Mr. Mills, who is present to my left.
And you, sir, James Mills?
Yes, ma'am.
Thank you. Today is the date for probation violation hearing.
Oh,
I just want
oops.
to,
Adulting.
remind you, Mr. Mills,
It's tragic.
you're accused of a probation violation. When you entered your plea in this case, it was to an offense punishable by up to 93 days in jail. So if you're found to have violated probation, you face up to 93 days of credit for any time that you've already served. You also have a special status. So if you're found to have violated your probation, you could lose that special status and have this crime enter on your public criminal history. One of the offenses is a mandatory revocation of that status if you're found guilty of it. You have the right to have an attorney. Mr.
careful,
Raleigh
buddy.
is your attorney. You have the right to have a hearing where it must be proven.
I'd be
by
worried if I
preponderance
was
of the
him.
Evidence you violated the terms of your probation.
Wow, steak.
The
Look at
alleged
you,
violations
Carol.
today
My
are
God.
Technical violation, failure to enroll in random drug testing.
God.
Non-technical violation, left the state of Michigan without permission from the court. Non-technical violation, failure to adhere to the no contact order on January 10th.
Uh-oh.
Non-technical violation, displayed assaultive or threatening behavior on or around January 10th. My understanding, the parties wish to proceed to a hearing. Are there preliminary matters before? we
Somebody
continue?
going back to jail, I think.
No, you're
I have a very good feeling he is going to jail.
Then Mr. Mills, you may have a seat. Ms. McCray, your first witness.
Thank you.
McCray,
This
Cray.
time People would call on probation officer Brendan Hanna.
Time will tell, Doug.
Only time will tell. There's 2 channels, so Got a 50-50 chance.
Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
I do.
Oh, I do not like this probation
All right,
officer
state your name
already.
for
I'm
the record.
sorry, but
Brendan Hanna.
oh
Thank you.
boy.
Questions for witness Hannah?
Thank you, Your Honor. Good afternoon, Mr. Hannah. How are you?
Pretty good about you.
Doing good, thank you. All right, how are you employed?
I'm a probation officer for the city of Lansing.
Okay.
Right, we have Instagram.
During your
I will
time
look at
working as a
We're on the
capacity as
gram,
a
bro.
probation officer for the city of Lansing, did you ever know or meet someone by the name of James Eric Mills?
I have,
Okay, and how do you know him?
he's on my caseload.
Okay, what is he on your caseload for?
A charge of domestic violence.
Okay, and who was the victim in that domestic violence case?
The victim goes by the name of Jada Page.
Okay. Do you see Mr. Mills in the courtroom today?
I do.
Okay, where is he seated?
To my right, wearing a white shirt.
Okay, Your Honor, will the record reflect that this probation officer, Mr. Hannah, has identified the defendant, James Mills?
Any objection?
No objection.
Record will reflect ID.
Thank you, Your Honor. All right, Mr. Hannah, so as part of the defendant's probation requirements, was he required to enroll in random drug testing?
He was.
Okay, did he ever do that?
He did not.
Okay,
Uh-oh.
did you tell him that he had to do that?
We did, or I told him
You told him specifically? Okay,
during no orders.
okay. Did you give him a specific date he had to do it by?
Usually I give everyone a week to get it set up.
Uh-huh. So after a week, he hadn't signed up for that? Okay, did he reach out to you about why?
Just money issues.
Okay, but so he knew that he had to do it, right? Okay, and he told you that he knew he had to do it,
Yes.
He has to pay for it?
but for other reasons, he decided not to.
To pay for what, probation?
Now,
No, drug testing.
moving on to the other alleged violations.
Some people pay for probation.
Have you, throughout this probation period,
sure.
Mr.
Classes
Mills,
and
have you been in contact with the victim in the underlying case, Ms. Page?
I have.
Okay, tell me about some of that contact.
About $40 difference.
Contacted through email. And I think she contacted me once last summer, just asking about dropping a no contact order, and I never heard anything back. I just told her the process, and then she contacted me on January 10th, and then told me about the alleged contact between Mr. Mills and Jada Page.
Okay, and so when you said that she contacted you, was that through email?
Through email, yeah.
Okay.
No, because you could
Did she
totally get
identify
up with him and say, I don't have the
herself
money
as
right
Jada
now.
Page?
Yes,
Okay.
Yeah.
And
You
you
want me to
spoke to
do?
her previously via email, right?
yes,
Where she has identified herself.
yes.
Okay. You ever spoken to her on the phone?
I have not.
In this email on January 10th, 2023, what did she tell you?
She told me, in a nutshell, that she had contact with James, I think for something to do with their child switching.
Okay, let me stop you right there. She said that she had contact with Mr. Mills. What was the nature of that contact?
The nature of the contact.
Who do you call?
I'm not sure. Like,
Well, she
where
tried to
they
get
met,
it dropped
but,
at one point.
She said that.
That's
The week before she sent the email on January 10th, so it would have been around the beginning of the year. They got into it, it became physical. He left, or she left, he begged for her to come back, and she turned around and
Baby,
went
come
back.
back.
Then he began to hit me, slap me, and give me blows to the head. Every
Not
time
cool.
I tried to stand up and beg him to leave, he would hit me again. And then there's more. She went.
I'm hoping that was after
into
she
him being
tried to
a
get
great
that. job.
father, just not a great partner,
Mhm.
kind of thing. She kind of went into that and then mentioned how he went to Atlanta, Georgia.
Okay, so I want to take a step back still and talk about that contact.
She dropped a dime on him for leaving the
says that
state.
What was the word, punching her? Was that it? I don't want to.
So he said he began to hit me and slap me and gave me blows to the head.
Okay, now, did you ever receive pictures from Miss Page?
I did,
Okay, describe for the court that picture. Was it a picture or pictures?
just one picture.
Okay, and
Part
did
of our
you observe
tender plan,
anything
too.
on that picture?
I observed like a
Down in the
slight
keys.
cut on her, like, or it would be her left side of her lip on the bottom.
We're only
lip.
serving
Um,
Brussels
and
sprouts
the
and
picture was
peas.
selfie.
Okay, did you observe any bruises in that picture?
I did not in the picture. I just observed kind of the cut on the bottom.
Now, Did Ms. Page tell you about any other contact that she, with the defendant?
She is not.
Okay.
I thought you were going to show us the picture for a second.
Did she
Went black, but
provide
we're back.
you mentioned something about Atlanta, Georgia, is that correct?
Yes.
What did she say about Atlanta?
She said that Mr. Mills, she screenshotted a conversation of him telling her that he was on his way to Atlanta. And it's just like a text chain.
Can you read out the text, what the text says?
So from Mr. Mills,
Call this up
it says,
again.
I'm on the way to, my way to Atlanta. I'll be back on the 2nd of January. I'll get Junior and keep him until the 7th of January, and then we can get back to our schedule. I just need a vacation, so it'll all work out and everything. It'll be all.
Okay, so even taking out the Atlanta.
Oh,
trip, whether or
vacationing
not that
in
actually
the
happened,
beautiful
there
white
is
sandy
contact
beaches of
between the
Atlanta.
defendant, right, and the victim, Ms. Page.
Really
Okay, via the
unwind.
text message.
Yeah.
I need to slow things down. I'm going to Atlanta.
Well, you beat the shit out of her, Loud. So why?
Yeah.
I mean, I don't
Any
blame
other
her at that
information
point.
that you think is
She got beat up.
pertinent to this violation today?
I did not.
All right, I have no further questions.
Is there anything on the screenshots of the text that lead you to conclude that it's definitely Mr. Mills? Like, can you see his phone number on there? Is
I
it-
did not see his phone number. The only thing I could see was BB. That was it.
Ooh.
It says his name.
Ooh.
It
Interesting.
He was his
BD.
Baby daddy.
Oh, that stand for baby daddy.
I'm assuming.
Nice.
And
Baby.
Mr. Mills and Ms. Page have a child. in
Learned.
common?
Yes.
Okay.
If we learn anything about
And
Mr. Mills,
the-
he's
Don't mess with me, I'm one crazy mofo.
Incident about the beating at the house was involving children, right? Or their child in common?
I believe so. I don't want to say anything.
Okay, you don't know. That's okay if you don't know. All right. All right, I have nothing further.
Cross-examination.
Mr. Hannah, correct me if I'm wrong, I believe you said you do not know the location where this alleged assault would have occurred.
I do not.
And you know what date that might have occurred?
No.
And did she give you a time frame or a specific anything?
No time frame, no specific.
I'm hip.
Location.
I'm sorry, didn't she say it was a week prior to her email?
Oh, yeah, she did. So she said a week last week. So assuming it would have been around the beginning of the year. So it was January 10th when she had.
Those last week, is this supposed to be?
Yes.
Okay. Do you have any knowledge that there were any prior, during Mr. Mills' term of probation, any prior instances of assault or threatening behavior toward Ms. Page?
Not to my knowledge.
I'm down with the streets.
Regard to this alleged Atlanta trip, I believe you mentioned that that Ms. Page reported to you that
This attorney is
Mr. Mills told
terrible.
her he would be taking this trip, that he would be back on a certain day. Did she mention what day he was supposed to be back?
It's represented every single person.
In the text,
Or
it's
they did
terrible.
on
It
tape.
says,
It's terrible.
well, that's just when to keep his, their child. So there's no date specifically. when
Thought he
he's back.
said he'd be back around the 2nd.
No, he said he left around the 2nd.
Oh, he left
Yeah.
around the 2nd. And then he said get back to our schedule on the 7th, is that right?
Yep. It said just something about keeping their child in common until the 7th. of January.
Just to be
Common
clear, you
child.
said in the screenshot of the text message, the only thing identifying it as coming from Mr. Mills is the
BB.
initials BB.
Yes.
Was there a specific date and time?
I can
stamp
think
on
of a
that
few
text
things that
message
would go with
that would verify
BD.
the date and time that it was received?
No, it just says today as the iMessage.
Of course, you don't know when that screenshot was taken, or correct me if I'm wrong, but I don't.
I can't say for sure.
After receiving that email, did you receive any more emails from Ms. Page?
I received one more email with her. It was about a little over 24 hours after, basically telling me all of what she told me was, a lie. She just recanted her statement pretty much.
What?
General, basically taking back what she said.
Yes.
Not
Gotta
giving
be
you
right.
Specifics, but saying
Yeah.
that it was incorrect.
Yes.
All right, is that the last time you have communicated with Ms. Page?
Yeah, that's the last time she did it.
That would have been January 11th? I believe.
Actually, she my bad. She'd emailed me.
My bad.
James came in.
Is
for
he,
his arraignment,
is he a
asking
smooth
me
talker
what
and gets her to
showed
back
up
down
or
on
not.
everything? Is that what's happening over and over again?
I
That was
guess
last
so.
time. So that would have been recently. I don't know the exact date, but about
A little bit less than a
Anyway,
month
this
ago.
dude doesn't get locked up and go back to jail and probation
We've
done.
not received any further emails from her since the one we. canceled
Maybe.
the previous,
I'm starting to
activation.
think maybe.
Thank you.
You can't see his phone number, so you don't know if he's BD.
Right.
She's recanting her stories.
Miss Page never told you that those text messages were false, right?
No.
She never told you that she made up that screenshot, right?
No.
She never told you that it wasn't from Mr. Mills, right?
No.
She never said that the injuries on her face were made up, right?
No.
Okay, no problem.
All right, may this witness step down?
Yes, thank you, Judge.
Yes, Your Honor. Thank
Once again, the communication process is broken down.
No, Judge.
Mr.
But also,
Riley, any
Is she not there?
Did anybody question it though? I mean, did anybody
then we will
question?
proceed to argument.
Like, I understand what she said, but
Thank you, Judge. So as you know, the burden of proof is low at probation violation hearings. It's a preponderance of the evidence. Today, we heard testimony from Officer
Not closing arguments
Brendan Hanna,
already.
who received
Yeah,
an
moving
email on
quick.
January 10th of this year from Jada Page, who was the victim in the underlying case. She presented a screenshot where she said she had been speaking to Mr. Mills. She also said detailed an assault that happened to her. She further provided a picture showing, as Mr. Hanna testified, a bloody lip to show the injuries that she suffered. So at this time, Your Honor, I do believe that by a preponderance of the evidence, there is enough evidence to show that Mr. Mills displayed assaultive, threatening behavior on or around January 10th, 2023.
Good catch,
and or
by the way.
before that, I would say,
Lisa.
because the date is a week before that January 10th date, around then. And that he failed to adhere to the no contact order on or around January 10th, 2023, because he's had contact with Ms. Jada Page. I don't think that we have enough for the leaving the state charge. So I'll just leave that in your discretion.
Mr. Riley.
Your Honor, with
Oh,
regard
God.
to the alleged in-person contact and assault, all we have to go on for that is this email, which is frankly rather vague. Doesn't mention specific times or places. Doesn't offer any proof of any contact other than a photo of Ms. Page, which, as Mr. Hanna described, shows what might be a
He's
cut on her
moist,
lip, but
very moist.
certainly without Ms. Page here, we can't verify any other possible source of that cut. With regard to the text messages, again, we have a screenshot which does not offer much in the way of proving who sent it or when it was sent, or even specifically what it is referring to. And that would be the primary evidence of the alleged Georgia trip, which again, there isn't much to go on to demonstrate that that even occurred, much less specific times and dates, destinations, and so on.
Except for all
Frankly,
over
Your
his
Honor, I
IG,
don't
it's him
believe,
all
it
over
has
the
been shown beyond
hot
the
line.
limits of the evidence that
Should have been.
Mr.
You heard him
Mills
took that
left the
stuff
state of
down.
Michigan without consent of the court, that he violated the no contact order regarding Ms. Page, or that he engaged in assaulting or threatening behavior toward Ms. Page. Thank you.
Thank you.
Great job, dude.
Counselor, well, aware of the burden of proof it.
He didn't do
A
it.
probation violation hearing is preponderance of the evidence, which means more likely than not that the violations did in fact occur. We heard testimony today
There we go.
from just Mr. Hanna, who was relaying the information he received from Ms. Page and his supervision from probation. Mr. Hanna identified this gentleman here, Mr. Mills, as the gentleman who he supervises on a domestic violence charge. First, as to the technical violation, failure to enroll in random drug testing, the uncontested evidence is that Mr. Mills has failed to comply with that term and failed to enroll in drug testing. He was sentenced back in June of 22, so we are now
Hello, Tricia.
8 months into probation. He's yet to comply with that term.
Oh,
Mr. Mills
wow.
is guilty of that violation.
8
As to the
months.
non-technical violations, I find there is a preponderance of the evidence. Mr. Mills had contact with Ms. Page. Is evident from the
Yeah, with his
screenshots
fist to
that
her
were
bloody
sent
lip.
over, that I do believe by a preponderance of the evidence that that text came from Mr. Mills, and that it was a contact made with Ms. Page in violation of this court's order. Whether he was telling the truth about going to Georgia or not, I don't know. I won't find him guilty of leaving the state. And whether or not there was an assaultive contact, I guess I'm going to also sort of set that one because it's sort of, there's a cut lip. She, as far as I can tell, didn't make a police report. But the fact of the text in and of itself, to her saying,
perfect.
keep our kid until I get back and then we'll resume our schedule, was a violation in and of itself. So at this point, Mr. Mills is guilty of one technical violation, one non-technical violation. Do the people wish to be heard on the sentence?
Yeah, Judge, I do.
Good.
I think
Jail.
that, so at this time, the court has found him guilty of the technical violation of having contact with Ms. Jada Page. You know, I'm concerned at this point that, you know, Ms. Page has been hurt by maybe just even the contact, whether, you know, not getting into the assaultive alleged contact, because I know Your Honor found that was not proved by a preponderance of the evidence. I think it's clear that this defendant is not listening to this court's rules, and I believe he should have some consequences for that. It's very serious to violate this court's rules, especially when it comes to victims of domestic violence.
Violated a lot of
because
them.
it perpetuates the cycle. And so I would ask that he do some jail time so that he gets it in his head that this is not acceptable.
She's pretty ruthless. I like her.
I like her a lot.
Better with regard to the
Here comes the turtle.
violation of the no contact order, I think it is worth noting that the subject of the contact was caring for their shared child. It was not containing any sort of threatening or coercive language. And I certainly don't think Mr. Mills is using text to engage in that sort of conduct, and so I hope it will be treated accordingly.
I say 30 days. He's gonna get 30 days. Yeah, I'll drop it.
I also like how she had pointed out that the bar is set kind of low as far as having to prove these things when it comes to this type of a case. I thought that was kind of interesting.
And it just shows the manipulation he has over that woman as well. Have her, recanting constantly.
Oh, yeah, a few times. Yeah, not just once.
I mean, he's got her recanting and going back on everything. And
he might have a little boing boing
Mr.
happening.
Mills
He likes a strong woman,
probation
maybe.
than I would typically give in this circumstance because of his behavior, higher on bond. He wasn't cooperative with getting his counseling going. He has missed counseling. He never got testing going. I had concerns. There was a deferral of an assaultive prior, but we haven't made much progress, particularly in light of the fact that I think Mr. Mills thinks he can have contact and we won't know, and he won't receive a consequence for it. So sentence is 7694A is revoked as required by statute. Probation is revoked. 93 days in jail with credit for 4 days.
93 to 89 left.
Fees will be taken off your account because you did not use that 10 months of probation, but you do owe the balance. You are to report to the collections department when you're released from jail to make arrangements to pay the remainder.
I'm going to
If you'd like to appeal my sentence and you need a public defender to assist you, you need to make your application within 14 days. Anything else we need to address for the record?
No, on behalf of the people, thank you.
Oh, Your Honor, thank you.
I'm glad to see that. That was 2 months more than I thought. I thought you were spot on with the 30 days. That's what I was thinking.
Yeah.
Probably if he got himself a good lawyer, probably could do that on weekends. But as far as that goes, good. 94 days or 93 days with 4 days already. Damn.
I mean, he kind of had it coming. You know, it seemed like if he did half of the stuff they said, I mean, even without being able to prove the other things, him failing to do the drug testing as ordered is a violation. He violates his probation then. So right off the top, I would think that would be pretty damn close to getting that done. I dropped a link down below wherever you're watching at. That's where you'll be able to, if you go ahead and click it now and hit notify,
locking him up,
taking him right now.
Nice.
Look at
That's
that
the
shirt.
money shot, as they say, for today's We Got a Case.
taking them away. If you go ahead and click the link I just sent, you can go ahead and click notifications on there. You'll hit that you want to be notified once it goes live, and you'll get a notification and all that good stuff. So it should fairly simple. Yeah, put them into cuffs, cuff them and stuff them, take them right out of here.
We don't get to see that very often.
Justice served right in front of us, hot and fresh.
Great. All right, guys. So don't forget about that happening later. And also, don't forget Taco Tuesday today.
Yummy, delicious tacos. And we're going to South Africa, which I think near Cape Town. So if you're familiar with that area, maybe you'll see some places you'll be able to say, hey, there goes the old 7-Eleven over there. So be back for that. We got a lot of crazy stuff happening on. We got a chase today at 4:05. 4:05.
Thank you, guys. Hey, Ben Flipping Goods, good to see you, bud. Hope you're doing well. No G around here.
Yeah. Just like those people's names scrolling right there across the bottom of the screen.
Yeah, Flush of Golf and Guns and Cali ×2, by the way, membership and some Australian doll hairs. Appreciate you guys a ton, all the likes, new subs, and everybody in the chat. My God, Dallas Alice, good luck with the new doorknobs. I hope that he got the doorknobs that are actually like the handles, because I would never want to live in a house with round doorknobs again. Do you have the handle? You know what I'm talking about? The little handle.
Yeah.
I couldn't imagine.
That's an upgrade, Creed.
Heck yeah, it is. Living good. Newest thing that Facebook, TikTok thinks that I want to see are people calling out their friends for being poor. I guess you're poor if you have your couch is against a wall.
All right.
That's a trend, Mikey.
I'm halfway there, Creed. I got one against a wall and one not against a wall. So
I think they call that a median income. Kind of living in the middle. Ours way out in the room. So we're good.
Living that good life, Creed.
That's right. Let's see you guys at 4:05 Eastern again. Flush of Golf and Guns and Cali. Appreciate you guys a ton. And Taco Tuesday's next. Looking forward to it.
That's right. Until the next time, hang in there. He was great today.
He was
great.